Is there anything more maddening than pouring your heart into owning something legit, handed down from your grandfather with every paper in place, only to have a stranger stroll up and declare, "This belongs to the community now"? I used to scoff at that kind of drama, thinking it was pure movie magic, until a neighbor I'd never even shared a barbecue with marched over, announcing she'd throw a party on my private lake. And she wasn't kidding. She showed up with lawyers, ballots, and even vacation itineraries. From that instant, I was thrust into the wildest legal showdown any rational person could dream up. I'm Dylan Mercer, and 3 years ago I inherited a breathtaking 2 1/2 acre haven in Pine Ridge Estates, just outside Charlotte, North Carolina, a crystal-clear lake my grandfather cherished since the 1950s. When he passed, he left me not just the land, but memories of lazy summer fishing afternoons and serene evenings watching the sunset dance on the water. As a freelance graphic designer, I could work from anywhere, and no spot felt more right than the old cabin overlooking that lake, my slice of simple, peaceful bliss. That all flipped the day Whitney Lark moved in next door. At 31, with her auburn bob styled to perfection and a wardrobe shouting "professional on a mission." Whitney wore business casual even to check her mail, like she was always prepped for a big meeting. I later learned she'd been a radio host at the local station until a scandal booted her out, but back then all I saw was her fierce determination to be Pine Ridge's most meddling neighbor. Which city of the United States are you watching from? Drop a comment and share with us if you have any confrontation with the HOA. We'll narrate your story on our channel. States History. Our first encounter happened on a Tuesday morning in late September. I was sitting on my dock with a cup of coffee, enjoying the morning mist rising off the lake, when I heard footsteps on the gravel path. Whitney appeared, wearing a cream-colored blazer and carrying what looked like a professional camera. "Good morning," she called out with a smile that was just a little too bright. "I'm Whitney Lark, your new neighbor from Maple Street. I hope you don't mind me walking through. I'm just getting acquainted with all the beautiful features of our community." The way she said our community struck me as odd, but I chalked it up to enthusiasm. "No problem at all," I replied, standing up to be polite. "I'm Dylan. Welcome to the neighborhood." She spent the next 10 minutes complimenting the lake, asking about the wildlife, and casually inquiring about community usage possibilities. When I mentioned that it was private property inherited from my grandfather, her smile flickered for just a moment before returning full force. Over the next few weeks, Whitney became a fixture at every homeowners association meeting. Pineridge Estates had always been a quiet community where the HOA met maybe twice a year to discuss street lighting or holiday decorations. But suddenly, we were having monthly meetings about community improvement initiatives. Whitney volunteered to be the communications coordinator and started publishing a glossy newsletter that arrived in everyone's mailbox every 2 weeks. The first issue seemed harmless enough. Profiles of new residents, reminders about trash pickup, schedules, and a feature about maximizing our community assets. That phrase stuck with me, especially when I noticed the newsletter included professional photos of my lake taken from various angles around the neighborhood. The second newsletter was more direct. There was an entire article about underutilized spaces and the benefits of shared recreational facilities. It talked about how other communities had successfully implemented community management of private amenities, always with quotes around phrases that made me increasingly uncomfortable. The article mentioned property values, community cohesion, and environmental stewardship, but what really caught my attention was the byline: "Special thanks to legal consultant Trent Holloway for research assistance." I'd never heard of Trent Holloway, but something about a legal consultant being involved in newsletter articles about my lake made my stomach tighten. Hank Brewster, my neighbor across the street, stopped by that same afternoon. Hank was 58, a retired city planning inspector who'd lived in Pine Ridge for over 20 years. He had the no-nonsense attitude of someone who dealt with bureaucrats and developers his entire career. "Dylan," he said, settling into one of my porch chairs, "that woman's been asking everyone about property lines. She wanted to know if anyone had copies of the original surveys, and she's been real interested in how the HOA bylaws define community property." He paused, looking out at the lake. "I've seen this playbook before, son. You might want to be careful." I thanked Hank for the warning, but part of me still thought Whitney was just an overly enthusiastic neighbor who didn't understand boundaries. That illusion shattered when I found the third newsletter in my mailbox, along with a formal letter from the Pine Ridge Estates Homeowners Association. The newsletter featured my lake on the cover with the headline, "Community Recreational Opportunities, a Vision for Our Future." Inside was a detailed proposal for turning private amenities into shared resources, complete with architectural sketches and financial projections. But it was the letter that made my blood run cold. Community meeting discussion of recreational facility management. Your attendance is required as a concerned property owner. Failure to attend will be considered acceptance of community proposals. The meeting was scheduled for the following Sunday at 2 p.m. in the afternoon. Sunday arrived with unseasonably warm weather, the kind of day that should have been perfect for sitting by the lake with a good book. Instead, I found myself walking into the Pine Ridge Estates Community Center, a modest building that usually hosted book clubs and holiday parties. Today it felt more like a courtroom. 18 residents had shown up, which was more than had attended any HOA meeting in the 5 years I'd lived here. Most people looked confused, clutching copies of Whitney's newsletter and whispering among themselves about what exactly we were supposed to be discussing. Whitney had transformed the front of the room into something resembling a corporate boardroom. She'd set up a projector, arranged chairs in formal rows, and even provided bottled water and printed agendas. She was wearing a navy blazer with pearl jewelry, looking every inch the professional presenter. Standing beside her was a man I didn't recognize. Tall, probably in his late 40s, with silver hair and an expensive suit that screamed lawyer. When Whitney called the meeting to order, she introduced him as Trent Holloway, our volunteer legal advisor, who's graciously agreed to help us navigate the complexities of community property management. "Thank you all for coming," Whitney began, her radio voice carrying clearly through the room. "Today, we're going to discuss an exciting opportunity to enhance our community while addressing some important safety and environmental concerns." She clicked to her first slide, a professional photograph of my lake with the title Pine Ridge Estates Community Recreation Development Plan. My heart sank as I realized this wasn't going to be a discussion. It was going to be a presentation, designed to sell the other residents on taking my property. Whitney's presentation was masterful in its manipulation. She talked about environmental benefits, explaining how professional management would ensure proper water quality and wildlife protection. She discussed property value increases that would result from having managed community amenities. She showed pictures of other neighborhoods with shared facilities, emphasizing how they'd built stronger communities and happier residents. Every few slides, she'd mentioned safety concerns about unsupervised recreational areas and the liability issues that could affect the entire HOA if someone were injured on private property that wasn't properly maintained. Trent Holloway's contribution was even more disturbing. He spoke with the casual authority of someone who'd done this many times before, referencing precedent cases in Westchester County and established legal frameworks for community asset management. He pulled out what looked like official surveys and legal documents, spreading them across a table while explaining how property boundaries from the 1950s were often unclear by modern standards and how reasonable compensation models had been worked out in similar situations. The way he casually mentioned other cases made me realize this wasn't Whitney's amateur hour. This was a professional operation. The community's reaction was exactly what Whitney had hoped for. 3 residents immediately expressed enthusiastic support, talking about how wonderful it would be to have a place for their grandchildren to swim and fish. 6 others seemed confused but swayed by the professional presentation and talk of increased property values. Margaret Maggie Connors, a 72-year-old widow who'd lived in Pine Ridge for 45 years, asked pointed questions about legal authority and compensation. But Whitney smoothly deflected with talk about community collaboration and win-win solutions. Hank Brewster was openly skeptical, asking about property surveys and whether anyone had actually verified the claims about unclear boundaries. But when I tried to speak up, explaining that the lake was clearly within my property lines and had been privately owned by my family for 70 years, Whitney's supporters quickly painted me as uncooperative and selfish. "We're not trying to take anything from you, Dylan," Whitney said with fake sympathy. "We're trying to work together for the good of everyone." The way she emphasized everyone while looking around the room made it clear who was supposed to be the villain in this scenario. Connie Reeves, the HOA secretary and a careful accountant by profession, took detailed notes throughout the meeting, but looked increasingly uncomfortable with the aggressive approach. When someone asked about the cost of this community management, Whitney quickly deflected to Trent, who talked about modest administrative fees and shared responsibility models without giving any actual numbers. I noticed Connie writing question marks in her notes and underlining certain phrases, but she didn't voice her concerns during the meeting. As the presentation wound down, Whitney announced that she would be running for HOA president in the upcoming election with a platform focused on maximizing community resources and building stronger neighborhoods. The timing wasn't coincidental. She needed the authority of the presidency to push through her L-rabbing scheme. A motion was raised to explore legal options for community access to my property, and despite my vocal objections, it passed by a vote of 11 to 7. I felt completely isolated as neighbors I'd known for years voted against me based on a slick presentation and professional-look legal documents. After the official meeting ended, Trent Holloway approached me with what I can only describe as a predatory smile. "Mr. Mercer," he said quietly, "this can go easy or hard. Community sentiment is clearly shifting towards shared resources. Maybe we should discuss a mutually beneficial arrangement before this gets more complicated." The threat was veiled but unmistakable. Cooperate or face the full force of legal and community pressure. I mumbled something about needing to think it over and left the meeting feeling like I'd just been mugged by a PowerPoint presentation. Walking back to my house, I could see my beautiful lake shimmering in the afternoon sun. The same view my grandfather had enjoyed for decades, but now it felt different, threatened. I realized that Whitney and Trent had just declared war on my family's legacy, and they'd managed to turn half my neighbors into foot soldiers. The peaceful life I'd built here was about to become a battlefield, and I had no idea how to fight back. The next morning, I woke up to find my lake surrounded by official-looking people in matching polo shirts carrying clipboards and equipment. They had set up what appeared to be a professional environmental testing operation, complete with a white van emblazed with EcoEst solutions and uniformed technicians taking water samples. I threw on clothes and ran down to confront them, but they had permits, actual official-looking permits, that cited public health concerns and community safety assessments. When I demanded to know who had authorized this invasion of my private property, they politely referred me to their supervisor, who wasn't on site, but could be reached through Whitney Lark. By the time I tracked down Whitney's phone number and got her on the line, she was already 3 steps ahead of me. "Oh, Dylan, I'm so glad you called," she said, with fake enthusiasm. "The environmental assessment was my idea, but it's completely legitimate. We have concerns about potential algae blooms and water quality issues that could affect the entire neighborhood. I'm sure you want to be a responsible property owner." The way she twisted it made me sound unreasonable for objecting to strangers testing my private lake. When I pointed out that I'd never given permission, she smoothly explained that the permits were issued based on community health concerns and that I couldn't legally interfere with a legitimate environmental assessment. That afternoon, I called every lawyer in Charlotte until I found one willing to take my case. Valerie Grant was 43 years old, a former public defender who'd specialized in property rights cases for the past 15 years. Her office was modest, but organized, filled with law books and case files that suggested someone who actually fought for her clients rather than just collecting fees. "Mr. Mercer," she said after I'd explained my situation, "what you're describing sounds like a coordinated harassment campaign designed to force you into an unfavorable settlement. But before we can fight it, we need to understand exactly what we're up against." Valerie's investigation started with Trent Holloway, and what she found was disturbing. Trent had a reputation for creative legal interpretations and had been involved in at least 6 similar cases across 3 states. His specialty was finding technical loopholes in property law and HOA regulations that could be exploited to pressure homeowners into giving up their rights. He'd been disciplined twice by the State Bar Association, once for misrepresenting facts in a property dispute and once for conflicts of interest involving development companies. This man is not providing free legal advice out of the goodness of his heart. Valerie told me he's working an angle and we need to figure out what it is. Meanwhile, Whitney's media campaign was hitting full stride. The local newspaper ran a front-page story titled "Community Seeks Equitable Access to Neighborhood Amenities," featuring quotes from concerned residents and official-sounding statements about environmental responsibility. Whitney's background in radio was evident in how smoothly she handled the interview, positioning herself as a community advocate fighting for fairness against an uncooperative property owner. The article included several photos of my lake taken with professional equipment, making it look like a public resource that was being hoarded by one selfish resident. The environmental testing results when they came back were predictably alarming. EcoEst Solutions reported preliminary findings of potential algae concerns and recommended immediate professional management to prevent health hazards. The report was filled with scientific-sounding language and official-looking charts. But when Valerie had it reviewed by an actual environmental scientist, the problems became clear. The testing methodology was flawed, the data was incomplete, and several of the concerning measurements were within normal ranges for natural lakes. Most damning of all, EcoTest Solutions had been incorporated just 3 weeks before Whitney hired them with an address that traced back to a strip mall office suite. The community was rapidly dividing into factions. Whitney's supporters were becoming more vocal, organizing concerned neighbor groups and scheduling informal meetings to discuss the lake situation. They began taking shifts to monitor my property, claiming they were documenting environmental compliance and community safety issues. Every morning, I'd see someone with a notebook standing at the edge of my property line, taking pictures and making notes. The psychological pressure was intense. I couldn't enjoy my own lake without feeling like I was being watched and judged by people who decided I was the neighborhood villain. Hank Brewster proved to be a valuable ally. His background in city planning meant he knew how to read property, surveys, and zoning documents, and he spent several days at the county records office researching my property's history. What he found strengthened my case considerably. My grandfather's deed was crystal clear. The property boundaries had been properly surveyed in 1952 and again in 1978, and there had never been any ambiguity about the lake's ownership. More importantly, Hank discovered that Whitney had been asking very specific questions about property, values and development potential, suggesting her interest went beyond community swimming pools. The harassment escalated when I started receiving official-looking letters about environmental compliance violations and community safety concerns. Each letter demanded responses within impossible timeframes and threatened legal action if I didn't cooperate with various inspections and assessments. Valerie recognized the tactic immediately. It was designed to overwhelm me with bureaucratic pressure until I agreed to negotiate just to make it stop. They're trying to make fighting more expensive and stressful than surrendering, she explained. It's a war of attrition, and they're betting you'll fold before they do. But the final straw came when I arrived home from the grocery store to find an official notice taped to my front door. Preliminary injunction hearing. The court will determine temporary access arrangements pending full environmental review. Whitney and Trent had filed for a court order that would force me to allow community access to my lake while their bogus environmental concerns were being resolved. The hearing was scheduled for 10 days away, barely enough time to prepare a defense against what was clearly a coordinated legal assault on my property rights. Valerie's deeper investigation revealed connections that transformed my understanding of what I was fighting. Trent Holloway wasn't just Whitney's legal advisor. He was part of a network that included Pinnacle Development Corporation, a company that specialized in purchasing residential properties for commercial development projects. Phone records showed regular communication between Trent and Greg Talbot, Pinnacle's regional acquisition manager, dating back 6 months before Whitney had even moved to Pine Ridge Estates. This wasn't a spontaneous community initiative. It was a calculated business operation disguised as neighborhood activism. The pieces started falling into place when Valerie discovered that Pinnacle had quietly purchased 2 other properties in Pine Ridge Estates over the past year, both from elderly residents who'd been pressured to sell by community development concerns. Greg Talbot had a pattern of using legal harassment and social pressure to force out homeowners who wouldn't sell voluntarily, then swooping in with generous offers once people were exhausted by the fight. My lake property was the crown jewel, 2.5 acres of waterfront land that would be perfect for a luxury resort or high-end residential development. Whitney's role became clearer when we traced her financial records. She'd been receiving monthly payments from something called Community Development Consulting, which turned out to be a shell company owned by Trent Holloway. The payments started 2 months before she moved to Pine Ridge Estates, which meant her entire presence in our neighborhood was part of the plan. Her job was to infiltrate the community, build support for shared resources, and create legal justification for forcing me to give up my property rights. The failed radio career and financial desperation had made her the perfect recruit for this kind of operation. The fake environmental testing was just one part of a sophisticated campaign. EcoEst Solutions was owned by Trent's brother-in-law, and their equipment was mostly props designed to look official in photographs. The real goal was to create a paper trail of environmental concerns that could be used to justify legal action and community pressure. When local newspapers printed stories about potential health hazards, they were unknowingly amplifying a coordinated disinformation campaign designed to turn public opinion against me. But Whitney and Trent had made one crucial mistake. They'd underestimated the intelligence and integrity of long-term residents like Hank Brewster and Maggie Connors. Maggie had lived through a similar developer harassment campaign 25 years earlier, when a different company had tried to force out residents of her previous neighborhood. She recognized the pattern immediately. The fake community concerns, the professional presentations, the sudden urgency about problems that had never existed before. They destroyed my old neighborhood, she told me quietly. Turned neighbors against each other until everyone was so miserable they just wanted to sell and leave. I won't let it happen again. Hank's investigation uncovered even more disturbing evidence. Whitney had never registered to vote locally despite claiming to be invested in community leadership. Her rental house was 3 months behind on payments, and she'd been evicted from 2 previous addresses in other states. Most damning of all, property records showed that Pinnacle Development had placed options on 4 more houses in Pine Ridge Estates contingent on successful resolution of environmental and zoning concerns. If they got my lake, they could force out half the neighborhood and build their resort project. Connie Reeves, the HOA secretary, made a discovery that changed everything. While reviewing the association's financial records, she found unexplained expenses totaling over $15,000 in legal research and consulting fees that had been approved by Whitney without proper board authorization. The money had been paid to Shell, companies that traced back to Trent Holloway's operation, meaning they'd been using HOA funds to finance their attack on my property. When Connie brought this to the attention of other board members, several residents who'd initially supported, Whitney began asking uncomfortable questions. The surveillance of my property intensified as Whitney realized her support was eroding. She organized what she called a community safety patrol that took shifts monitoring my lake for environmental compliance violations. 4 neighbors who'd been promised positions in Whitney's administration agreed to spend several hours each day watching my property and documenting anything that could be construed as a violation. They carried official-looking notebooks and took photographs of everything from my dock maintenance to the wildlife that visited the lake, creating an atmosphere of constant scrutiny that made me feel like a prisoner in my own home. The psychological pressure was designed to break me down. Every day brought new concerns about my property management, new demands for documentation, and new threats of legal action. Whitney would show up at my door with fake smiles and veiled threats, always accompanied by neighbors who could serve as witnesses to my uncooperative attitude. The goal was to make fighting more exhausting than surrendering, to wear me down, until I agreed to their terms just to make the harassment stop. But they'd made one fatal error. They'd assumed I was alone in this fight. What they didn't realize was that their aggressive tactics were creating sympathy for my position and suspicion about their motives. Residents who'd initially been neutral were starting to ask why Whitney was so desperate to get control of my lake and why a volunteer legal advisor was working so hard on what should have been a simple community issue. The preliminary injunction hearing was still a week away, but the tide of public opinion was beginning to turn. The question was whether it would turn fast enough to save my property. With Valerie's help, I decided to stop playing defense and start fighting back. Our first move was to document everything, and I mean everything. We installed security cameras around my property to record the constant surveillance and harassment. We started keeping detailed logs of every interaction, every threatening letter, and every suspicious activity. Most importantly, we began building a counter-narrative that exposed Whitney's true agenda and the people behind her operation. The breakthrough came when Valerie's private investigator obtained phone records showing the extent of coordination between Whitney, Trent, and Greg Talbot from Pinnacle Development. The calls weren't just frequent, they were strategic, timed around HOA meetings, newspaper interviews, and legal filings. The pattern revealed a level of planning and coordination that went far beyond community activism. This was corporate espionage, disguised as neighborhood politics, and we finally had the evidence to prove it. But our biggest weapon turned out to be Whitney's own arrogance. Confident that her plan was working perfectly, she became increasingly careless about hiding her true motives. During what she thought was a private conversation with Trent at a local restaurant, she made comments about exit strategies and backup plans that were overheard and reported by other diners. More damaging still, she began talking openly about her planned HOA presidency and how she intended to use that position to clean up property management issues throughout the neighborhood. The security footage proved invaluable in exposing the harassment campaign. We captured Whitney trespassing on my property at night, taking photographs and measurements that had nothing to do with environmental concerns. We recorded her supporters, coaching each other on what to say during their monitoring shifts, revealing that their environmental concerns were scripted rather than genuine. Most damning of all, we caught Trent Holloway meeting with the fake environmental testers, handing them envelopes that clearly contain payment or instructions. Whitney's media strategy began backfiring as residents started asking harder questions. When she organized an emergency community meeting about escalating tensions, she expected sympathy and support. Instead, she faced increasingly hostile questions about her background, her funding, and her real agenda. Maggie Connor stood up during the meeting with 45 years of neighborhood credibility behind her and directly challenged Whitney's claims. "Young lady, I've lived here longer than you've been alive, and we've never had environmental problems with that lake. What we have is a problem with outsiders trying to manipulate our community for their own benefit." The meeting descended into chaos when Connie Reeves presented her financial audit. Standing at the front of the room with spreadsheets and bank records, she methodically explained how $15,000 in HOA funds had been diverted to shell companies connected to Trent Holloway. Whitney approved these expenditures without board authorization. Connie announced her accountant's precision cutting through Whitney's explanations. "We've been paying for the legal attack on Dylan's property with our own community funds." The revelation stunned residents who'd trusted Whitney with their money and their votes. Whitney's response revealed the desperation behind her polished facade. She broke down in what appeared to be genuine tears, claiming she felt threatened and intimidated by the questions and accusations. But her emotional display backfired when Hank Brewster calmly presented his timeline of her deception, showing how every element of her story had been carefully constructed to manipulate community sentiment. 3 residents walked out in disgust when they realized how thoroughly they'd been played. Trent Holloway tried to distance himself from the controversy by claiming Whitney had exceeded his recommendations and acted independently, but Valerie had phone records proving their coordination, and his attempt to throw Whitney under the bus only made both of them look worse when he tried to present evidence of my hostile behavior. The security footage revealed that his evidence had been edited to remove context and create false impressions. The professional legal advisor was exposed as a fraud who manufactured evidence to support predetermined conclusions. The tide turned decisively when Judge Patricia Washington was assigned to our preliminary injunction hearing. Valerie's research revealed that Judge Washington had previously ruled against Trent Holloway in a case involving questionable property claims, and she had a reputation for harsh treatment of lawyers who manipulated evidence or misrepresented facts. "Mr. Mercer," Valerie told me, "we just got the break we needed. Judge Washington doesn't tolerate the kind of games Trent's been playing." But Whitney wasn't finished. Realizing that her legal and political strategies were failing, she made one final desperate move. She filed criminal complaints against me for threatening community safety and harassment of neighbors based on heavily edited recordings and out-of-context photographs. The charges were transparently false, but they succeeded in getting me arrested and creating newspaper headlines that painted me as dangerous and unstable. As I sat in a jail cell waiting for Valerie to arrange bail, I realized that Whitney was willing to destroy my reputation and freedom to get what she wanted. The arrest was meant to intimidate me and to surrender, but it had the opposite effect. The transparent falseness of the charges, combined with the evidence we'd already gathered, made Whitney look desperate and vindictive. More importantly, it gave us grounds for federal charges related to conspiracy and wire fraud. Valerie called me from the police station with news that changed everything. "Dylan, the FBI is opening an investigation into Pinnacle Development's multi-state property acquisition scheme. Your case isn't isolated. It's part of a pattern that spans several states and dozens of victims. The 24 hours before my court hearing felt like the calm before a hurricane. Valerie worked through the night, preparing our defense, while Whitney made increasingly desperate attempts to salvage her crumbling conspiracy. The criminal charges against me were transparently false, but they'd succeeded in making me a reluctant public figure. As local media covered the property rights battle that had divided Pineridge Estates, I found myself thrust into a spotlight I'd never wanted, forced to defend not just my lake, but my entire character against a coordinated smear campaign. Whitney's desperation became evident when she leaked our story to a regional newspaper, hoping to gain sympathy by portraying herself as a community advocate being bullied by a selfish property owner. The article, titled "Property Rights versus Community Needs," painted me as an uncooperative neighbor who was denying children access to swimming and recreation. But the strategy backfired when the reporter's investigation uncovered inconsistencies in Whitney's story and raised questions about her funding and motivations. Instead of generating sympathy, the article brought unwanted scrutiny to her operation. The biggest breakthrough came when Valerie's investigator obtained a recording of a phone conversation between Whitney Trent and Greg Talbot from Pinnacle Development. In their own words, they discussed their exit strategy if the legal approach failed, including plans to make Dylan Mercer's life hell until he gives up and sells. They talked about other potential targets for similar schemes across the region and referred to my case as a test run for a larger property acquisition program. The recording was devastating evidence of conspiracy and criminal intent. Meanwhile, the HOA was in complete chaos. Connie Reeves had called an emergency meeting to address the financial irregularities, and Whitney's remaining support collapsed when residents realized they'd been funding their own manipulation. The vote of no confidence passed 12-3, effectively, ending Whitney's political ambitions and removing her from any position of authority within the community. Several residents who initially supported her approached me privately to apologize and offer their testimony about how they'd been deceived. The community's awakening created its own momentum. Maggie Connor shared her story about the previous developer harassment campaign, helping neighbors understand how these schemes worked and why they needed to be stopped. Hank Brewster organized a petition supporting my property rights that was signed by over 20 residents, demonstrating that community sentiment had shifted dramatically. Even some of Whitney's former supporters admitted they'd been manipulated by professional presentations and false environmental claims. But the personal toll was enormous. I'd barely slept in weeks. The stress was affecting my work and health, and I found myself questioning whether fighting was worth the cost. And the peaceful life I'd built around my grandfather's lake had been shattered, replaced by constant conflict and public scrutiny. There were moments when selling the property and moving away seemed like the easiest solution, especially when I considered the legal bills and the damage to my relationships with neighbors who still believed Whitney's lies. As darkness fell, the night before the hearing, I found myself standing alone on the dock where this nightmare had essentially begun. The water stretched before me like black glass, perfectly still, except for the occasional ripple from a fish breaking the surface. Around the lake's perimeter, lights glowed from houses where neighbors sat with their families, probably watching television or helping kids with homework. Normal evening activities that seemed impossibly distant from my reality. The isolation was crushing. I felt like I was living in a different world from everyone else, separated by legal battles and conspiracy theories that most people couldn't even comprehend. It was in that moment of solitude that I remembered something my grandfather had told me when I was 12 years old. We'd been sitting in these same chairs fishing for bass as the sun set behind the pine trees when he started talking about the developers who'd tried to buy his land in the 1980s. "Dylan," he'd said, his weathered hands steady on his fishing rod, There's always going to be someone with smooth talk and fancy papers who wants to take what you've got. They'll tell you it's for the greater good, or that you're being selfish, or that you don't really understand what's best for everyone. But here's what I learned fighting in Korea. When someone's trying to take something from you with words instead of force, it's because they know they don't have the right to take it at all. Don't ever let anyone steal your birthright with smooth talk and legal tricks. I'd been too young then to fully understand what he meant. But sitting there in the darkness with legal papers scattered across my kitchen table and the weight of an entire community's judgment on my shoulders, his words took on new meaning. This wasn't just about property rights or environmental concerns or community development. It was about whether people like Whitney and Trent could use manipulation and legal harassment to steal what belonged to others. My grandfather had fought actual wars to protect freedom and property rights. The least I could do was fight a legal battle to protect what he'd left me. The memory gave me strength, but it also highlighted how alone I felt in this fight. Looking across the lake at those glowing windows, I wondered how many of my neighbors understood what was really at stake here. Were they thinking about the precedent this case would set, or were they just relieved that the drama would finally be over regardless of the outcome? The lights seemed to mock my isolation, reminding me that most people get to live their lives without worrying about corporate conspiracies and property fraud schemes. Valerie arrived early that morning with news that changed everything. The FBI investigation had moved faster than expected, and they'd uncovered evidence of similar schemes in 7 other states. Pinnacle Development's pattern of using legal harassment and community manipulation to force property sales was now the subject of a federal investigation. "Dylan," she said, "your willingness to fight instead of folding has exposed a criminal enterprise that's been destroying communities across the country." Judge Washington's reputation preceded her into the courtroom. A former prosecutor known for her harsh treatment of lawyers who bent the truth, she'd already reviewed the preliminary evidence and was clearly skeptical of Trent's claims. When Whitney tried to approach me outside the courthouse for one final attempt at intimidation, she was stopped by court security, who'd been briefed on the harassment campaign. "This is your last chance, Dylan," she hissed as she was led away. "Drop the charges, sign the agreement, and this all goes away. Otherwise, you haven't seen how ugly this can get." But I had seen how ugly it could get, and I was ready to end it. Walking into that courtroom, I knew that everything my grandfather had taught me about standing up to bullies was about to be put to the ultimate test. The peaceful lake that had started this conflict was about to become the center of a legal battle that would determine not just my future, but the future of property rights and community integrity across multiple states. As I took my seat behind Valerie, I could feel my grandfather's presence, his lessons about never surrendering to smooth-talking thieves, giving me the courage to see this fight through to the end. The courtroom was packed beyond capacity that morning, with residents from Pine Ridge Estates, local reporters, and even some faces I didn't recognize who'd apparently followed the story in the regional press. Whitney sat at the plaintiff's table, wearing a conservative business suit, still playing the role of the concerned community advocate despite everything that had been exposed about her operation. Trent Holloway looked confident beside her, surrounded by stacks of documents and folders that were meant to project professional competence, but would soon be revealed as elaborate props in a fraudulent scheme. Judge Patricia Washington entered with the stern demeanor of someone who'd seen every legal trick in the book and had little patience for games. Her reputation for dismantling dishonest attorneys was legendary, and Trent's subtle nervousness suggested he knew exactly what he was up against. "Ladies and gentlemen," she began, "we are here to determine the validity of claims regarding property access and environmental concerns. I want to make it clear from the outset that I will not tolerate misrepresentation of fact facts or manipulation of evidence in my courtroom. Brent opened with Whitney's testimony, and I had to admit it was compelling theatre. She spoke with practiced emotion about feeling terrorized and threatened by my resistance to community cooperation. She presented edited security footage that made me look aggressive and unreasonable, carefully omitting the context that would have revealed her trespassing and harassment. Her performance was polished, hitting all the right notes about community safety and environmental responsibility, while painting herself as a victim of an uncooperative neighbor who refused to consider anyone else's needs. The fake environmental evidence came next, with Trent presenting the Eco-Test Solutions report as if it were legitimate scientific analysis. He talked about algae concerns, water quality issues, and potential health hazards that required immediate professional management. The charts and graphs looked impressive, and if I hadn't known they were fabricated, I might have been convinced myself. Several character witnesses testified about my hostile behavior, poured community members, creating a narrative of an antisocial property owner who posed a threat to neighborhood harmony. But then Valerie stood up for our defense, and everything changed. Her first witness was Dr. Sarah Chen, an environmental scientist from the University of North Carolina, who'd reviewed the Eco-Test Solutions report. Dr. Chen systematically demolished every claim in the fake study, explaining how the testing methodology was flawed, the data was incomplete, and several measurements were actually within normal ranges for healthy natural lakes. This report, she stated clearly, would not meet the standards for a freshman environmental science class, let alone serve as the basis for legal action. The financial evidence came next, presented by a forensic accountant who traced the money trail connecting Whitney Trent and Pinnacle Development. The shell companies, the diverted HOA funds, and the payments to Whitney for her community organizing were laid out in devastating detail. When the accountant explained how $15,000 in community funds had been used to finance the legal attack on my property, several residents in the courtroom audibly gasped. Whitney's face went pale as her financial desperation and paid participation in the scheme were exposed. But the recording was what sealed their fate. When Valerie played the audio of Whitney Trent and Greg Talbot discussing their strategy to make Dylan Mercer's life hell until he gives up, the courtroom fell silent. In their own voices, they talked about manufacturing evidence, manipulating community sentiment, and using legal harassment to force property sales. Whitney's claim of being a concerned community advocate crumbled as her own words revealed the calculated nature of her operation. Whitney's composure finally cracked when she realized the extent of evidence against her. She began shouting accusations at Trent, claiming he'd told her everything was legal and that she'd been manipulated too. He said this was how community development worked, she screamed, pointing at Trent with shaking hands. He promised me a position with Pinnacle if I could get the lake. Trent tried to distance himself by claiming Whitney had exceeded his recommendations, but the recorded conversations proved their coordination was deliberate and extensive. Judge Washington's ruling was swift and comprehensive. All charges against me were dismissed with prejudice, meaning they couldn't be refiled. She ordered a formal investigation into Trent's law license and referred the case to federal prosecutors for potential criminal charges. Whitney was ordered to pay my legal fees and subjected to a permanent restraining order preventing her from approaching my property. Most satisfying of all, the judge specifically noted that the evidence revealed a coordinated conspiracy to defraud a property owner of his legal rights through manufactured evidence and community manipulation. The courtroom erupted in applause, from Pine Ridge Estates' residents who'd realized how thoroughly they'd been deceived. Maggie Connors was crying with relief, remembering her own experience with developer harassment decades earlier. Hank Brewster shook my hand with the satisfaction of someone who'd helped expose corruption in his own community. Even Connie Reeves, normally reserved and professional, allowed herself a smile as justice was finally served. The aftermath was even more satisfying than the courtroom victory. The local newspaper ran a front-page story titled "Property Rights: Fraud Exposed in Pine Ridge Case," detailing the conspiracy and its connections to similar schemes in other states. Whitney quietly moved out of the neighborhood in the middle of the night, avoiding the shame and legal consequences that awaited her. Trent Holloway faced investigation by the State Bar Association and potential federal charges for his role in the multi-state property fraud scheme. 6 months later, I received a letter from the State Attorney General's office informing me that my case had become the cornerstone of a comprehensive investigation into property rights fraud schemes. Pinnacle Development was facing charges in 7 states, and dozens of families who'd been victimized by similar operations were finally getting justice. My willingness to fight instead of surrender had exposed a criminal enterprise that had been destroying communities and stealing property across the country. Today I'm sitting on my dock, watching the sunset reflect off the lake that started this whole ordeal. The water is peaceful again, the harassment has ended, and my neighbors have returned to being actual neighbors instead of unwitting participants. In a corporate conspiracy, Whitney Lark and Trent Holloway learned the hard way that some people won't be bullied into giving up what's rightfully theirs. And for anyone facing a similar situation, remember that having the right paperwork doesn't mean you have to let someone walk all over it. Sometimes justice just needs a little patience and a good lawyer to set things right. The peace I have now feels even more precious because I fought for it. My grandfather's legacy is secure, my community is stronger, and property rights are a little more protected because we refuse to let criminals disguise themselves as community advocates. That's a victory worth fighting for, no matter how long it takes or how hard they try to break you down.